And good evening, everybody. My name is Jay Marsden, and you're watching Where There's a Will, There's a Way. It's a show about estate planning topics brought to you in hopefully a way that makes sense. We try to strip out all the legalese and give you a sense of some plain talk about some issues that we feel and some topics that we feel are near and dear to our heart, and we hope that they're near and dear to your heart too in terms of questions and advice and giving you some helpful information. So last show we talked about some documents that we think you should have as part of your estate plan. We're going to build on that idea now. We're going to talk about two other areas or two other documents that we think are very important for you to focus on and give you something to think about. We talk about estate planning with our clients all the time in sort of the three legs of a stool approach. One leg of the stool is this probate while you're alive concept. The second leg of the stool is the probate when you pass away concept. And the third leg of the stool is what happens if somebody gets sick and they need long-term care. Now, people ask all the time, Jay, you've got a couple of things that you seem to be doing. You seem to be an elder law attorney. You talk about estate planning. You say you're an estate planning attorney. And people ask all the time, what's the difference? Well, the difference is the estate planning attorney's concerns are always, if something happens to you and you pass away, how do your assets get to where you want your estate to go, your loved ones, your family, your friends, your charities? But the elder law attorney takes all of that into consideration, and then they ask the question, but what happens if you get sick and you need long-term care? So in previous episodes, we talked about what to do, how to handle things around if you get sick and you need long-term care and what directives you need to have in place. But tonight we're going to talk about more of the estate planning side of the house. Tonight we're going to talk about if something happens to you, how do you get your assets to where you want them to go? Now, the part of somebody's probate when you pass away plan that everybody's very, very familiar with is the good old-fashioned will, right? Everybody understands the concept of, I think I need to have a will. Most of our clients come in and they tell us, Jay, we did a will a number of years ago when the kids were little and we felt like it was time to become adults and we had to figure out who was going to get named the guardian of the kids, and if something happened to us, where would everything go? Now, the thing to keep in mind when it comes to your will is your will does exactly that. It names a couple of things. It names who would be guardians of your minor children if you have minor children. But it also names who would be your executor or your personal representative. Now, lawyers have a great habit of making sure that they use multiple words to say the same thing, which means the same thing over and over and over again. So executor, personal representative, they're the same thing, okay? So the language is a little bit different. We won't get into the details as to why, but we use them interchangeably. So your personal representative is the person who would make the decisions for you if you were no longer around as to where you want your things to go. Now, that person's job applies to only the things that are in your name alone when you pass away. So let me say that again. Your will only applies to the things that are in your name alone when you pass away. So for example, if you have a life insurance policy and that has a named beneficiary on it, that life insurance policy goes to the named beneficiary. It does not go through your will. If you have IRAs, if you have 401ks, if you have accounts that have a named beneficiary on them, those go to whoever the named beneficiary is on those accounts. It becomes a paper caper between the named beneficiary and wherever those accounts live, because accounts have to live somewhere. So if they live at the insurance company, it's a paper caper between the beneficiary and the life insurance company. If those monies live in an IRA or a 401k at a brokerage firm like a T. Rowe Price or a Fidelity or a Merrill Lynch, those accounts live at Merrill Lynch, and the person who's the named beneficiary, if something happens to you, they fill out paperwork between Fidelity and between T. Rowe Price and between Merrill. The court system is not getting involved at that point. Those accounts are not part of your probate assets. Your will only applies to the things that are in your name alone at your death. And think about it this way, okay? So I jokingly tell people all the time, if I'm shoveling the roof and I should somehow fall off the roof and I'm taken out of the picture, if you will. If my wife goes down to the bank and says, hey, look, my husband was with us, now he's not, and he has this account with you guys, and I'm the executor of the estate, and I want to access this account. The bank is going to say, well, we're sorry for your loss, but you know what? We don't know if your husband fell or if you pushed him off the roof. We have no idea. So we're not in the will business. Take the will that you brought, and people do this all the time. We get phone calls and people say, hey, I brought the will down to the bank and they wouldn't even talk to me about it. The bank is going to say, take that will and send that off to the probate court. And when you come back to us with a piece of paper that has a judge's signature on it, then we will take your instructions and do with this account what you tell us to do, which is to turn it into an asset of my estate. That's what that process looks like. When you have a will, everything that's just in your name alone, unfortunately, nobody knows where it's supposed to go. These accounts live at the bank, they live at Fidelity, they live at T. Rowe Price, they live in a CD, your car, unless you have two names on your car. All of those things that are in your name alone, the places that hold those assets, the places that hold those resources, they don't know what to do with them. And not only do they know what to do, not know what to do with them, they don't know who to listen to. And so that's when people go off and get appointed at the probate court and take that appointment paperwork and then go into the various places that those accounts live and say, I have been named the executor. Here's my appointment from the probate court. This account that's just in Jay's name, I need you to write me a check payable to my estate, and that person's job is to collect all of those accounts and put them into one bucket. They put those accounts into one estate account. And once those are all collected, then they sit down and they take a deep breath and they say, okay, now what do I do? All right? And the answer is they pay your bills. If you have any outstanding bills, the executor's job is to pay your bills using the money that's in the estate account. And then once that's all done, then they usually hang around for a little while longer. Now, how long? Well, it's about a year. And the reason it's a year is because creditors have a year to show up, raise their hand and say, Jay owes me money, all right? I know he's gone, but we have a bill here that needs to get paid, and they have a year to present it to the executor of your estate. Now remember, these are all the things that were just in your name alone. Now, it's very, very possible that there's not a lot of things in your name alone. Married couples, husbands and wives, spouses, in those situations, in many cases, people own things jointly. They have a joint ownership in real estate. They have a joint ownership in their brokerage account. They have a joint ownership in their bank accounts. They're joint on their checking accounts. And in many cases, none of those assets will go through probate. There'll be some paperwork. There's always paperwork. But that paperwork is going to be between somebody in the bank, somebody in the investment house, somebody in the registry of deeds to change the title on the house. So when we do planning for clients, we will explain to them, remember, the will only applies to things that you own in your name alone. And if that's the case and there's not a lot of things in somebody's name alone, then there might be very little probate that has to get done. But what usually happens is they may want to do some of the work to avoid probate down the road, and they'll ask us, well, how do I handle that? How do I avoid, if something happens to both of us, how do I avoid that situation where we have to go to probate because we both aren't around? And the thing that we will use for clients quite a bit is what's known as a trust. Now, people hear about trusts all the time, and then they say to themselves, Jay, I'm a little bit confused, I'm a little bit thrown off by this idea of a trust. It's very confusing to me. So we try to make it as simple as possible. The way we explain it to our clients is we say to them, look, all you're doing with a trust is you're taking the wishes that would normally go in your will and you're just putting them in your trust. That's it. It's no more simple. It's no more complicated than that. And then instead of being somebody's executor, the job is to be the trustee. Same job, just a slightly different, we tell people you're putting on a different hat. So now, if you set up a trust, what you're doing is you're making it very clear to everybody out there that there is a mechanism that's already in place that governs how these assets are going to get distributed. So for example, let's use the company we talked about earlier. Let's say that somebody has two accounts at Fidelity, and one of the accounts is in their name alone. They're going to have to go through probate. It's not going to be clear what should happen to that account because there's just one person's name on it. If that same account is held in a trust, Fidelity is going to say, well, we know that this account is held in the name of the trust. We know who the trustee is because we found that out when we opened up the account. We might even know who the backup trustee is because depending on how long the account's been open, we probably asked for that information. So now when the backup trustee shows up and knocks on Fidelity's door and says, this person is no longer with us and I'm the backup trustee, Fidelity will have them fill out some paperwork, and now they have the ability to do whatever the instructions are that are in that trust, just like they were in a will. But it becomes a paper caper between the trustee and Fidelity, and we don't have to get the probate court involved if the account has already been put into the trust. So remember, it's the same concept. It does the same thing that your will does, except by putting things in your trust now, you're basically saying to the world, if you will, look, we've already made arrangements for what's going to happen to the stuff in this account because it's in the name of our trust. Now, funding your trust, what does that mean? Well, what that means is you would do your estate planning, you would sign your estate planning documents, and then you would go to Fidelity and you would say to Fidelity, hey, dear Fidelity, I did some estate planning, here's my trust, my attorney said that I should come talk to you because I'm going to put some stuff in it, and I don't know what that means. How do I put stuff in a piece of paper? And what Fidelity's going to say is, we have paperwork, right? It's always paperwork. If you fill this paperwork out, your next statement when it comes in, instead of saying Jay and Kim Marsden, it's going to say the Marsden Family Trust with Jay and Kim in charge. And what we've done by doing that is we've basically funded our trust. We've changed the ownership so that the rest of the world can see that this money that's in this trust has some rules that have been written for it. And by the way, those rules are private. It's nobody's business what those rules say. All the people that have money in a trust, for example, all the places they have that just know who the current person who's in charge is, who's the current trustee, and then they know who the backup trustee is. It's on the trustee. It's their responsibility to make sure that that money goes where it's supposed to go. Just like the will says very publicly, here's where I want my stuff to go if I'm not around. The trust says the same exact thing, but you've already done some of the work for your loved ones so that when they have to do something, it's much easier and it's much more straightforward, and they're able to distribute those assets the same way they would in your will, but they do it much, much easier and with much less complexity than they would have to if they had to jump through some hoops at the probate court. So our preference, if we can do this for clients, is to say, look, we'd rather put things in your trust so that in a perfect world, you've got life insurance policies, those all have named beneficiaries. You have IRAs, you have 401ks, those all have named beneficiaries. You have taxable assets that would normally be held jointly, those are in the name of your trust. And if something happens to people, if they have those three things taken care of, all of that stuff goes to their loved ones outside of the probate process. It's very easy for the people who you ask to do the job for you, and it makes it very straightforward for the people who end up receiving those assets because it's a much less complicated project than it would be if you had to go down the probate court path and if you had to get somebody appointed through the will. Now, bank accounts and things like that, we refer to those, or we treat those as an operating account. We don't necessarily tell people that they really need to do a lot to get their bank account into the name of the trust because, again, it's your operating account. There's usually not a ton of money left in that account, and that money usually ends up going to whoever the joint owner is. We might have somebody get put on that account as a joint owner, and then they would just use that money to pay off whatever final bills, cell phone bills, some of the bills that come in last minute, kind of wrap those up. But the bulk of the assets, if you will, are held in the trust. If you want to put real estate in a trust, just like you went to Fidelity to change the name on the account, you have to go to the registry of deeds in whatever county you live in, and you got to sign some documents, and you got to put your house or your real estate in that trust, and that's how you accomplish that objective. You sign a deed, you sign some other documents, that moves everything into the trust, and if something were to happen to you, then you don't need any other court involvement, the trustee has the ability to turn these assets over right away and have them distributed as soon as possible, and that can really be as soon as somebody thinks it makes the most sense. But you've given them the ability and you've given them the authority to go ahead and do those things without jumping through the hoops of a trust, without jumping through the hoops of the probate court. Now, some people will ask us, well, Jay, if you're going to do a trust for me, I'm all set with the will thing. I don't need to have a will. Well, we always recommend, again, they kind of go hat in hand and they work together. We always recommend that in addition to having a trust, you have what's called a pour-over will. And just like the name implies, the idea is that anything that might have to go through the estate, anything that might have to get handled through the will, just literally your will says, give everything to my trust. That's all it says. If I'm not around, my will just says, give everything to my trust. And here's the executor. Here's who I want to do that. Could be the same as the trustee, could be a different person from the trustee. But the objective is to say, make sure that anything that I have that goes through my will goes into my trust. Now, what would a scenario look like for that? You say to yourself, well, that's kind of crazy. Why don't you just put everything right into your trust? Well, a couple of things. Oddly enough, people forget about stuff. They don't think they do when they always ask us, Jay, who forgets about money? Well, the state prints a gigantic list every year of all the people who have forgotten about money, right? So what happens? Things get forgotten about. That's where the will would come in that allows somebody easy access to get a hold of some of those assets. And again, give them to the trust or point them to your trust. God forbid something happens to you and then there's a lawsuit. So if there's lawsuits being brought on behalf of somebody's estate and somebody was to get some type of settlement, that check would be made out to somebody's estate, and then that money that's in the estate would go into the trust, and then it would follow your wishes. And one of the things that we like about the trust is it allows you to provide provisions for other folks. So for example, you can leave money to your kids, and then you can also make provisions that says, you know, God forbid something happens to one of my kids, I want this money to go to my grandkids. And I want to put some rules on it. I want to set some rules that say, look, if my grandkids are young, I want to put some barriers as to when they can access the money and what they can access that money for. All of us can think back to when we were young and wild and carefree and think to ourselves, we may have made different decisions, not all of them good, if we were somehow handed a pile of money at age 18 or 19 or 20, right? Sophomore year may not have turned into junior year. You might have gone off and done something different, and not always good. So the trust allows you to make decisions and control how some of this money is passed on to the next generation. And in many cases, as you get to know the next generation, you'll get a sense of, am I comfortable with somebody getting this money right away? Do I want this person to get this money later on down the road? Do I want to put some guardrails on how this money gets handled? And that way, you can have a sense of control and a feeling that if something ever happened to me, my estate and my legacy would pass on to the people that I wanted to pass on to, and safe in the knowledge that somebody is going to babysit this money for them until they reach the age that they can actually start to make some good decisions. And the other reason we jokingly tell people, because it's not always negative, we jokingly tell people, look, you want to have a will in place because if you're sitting at home and you scratch the winning lottery ticket and $5 million hits the table and you lean back in your chair and say, I won $5 million, if we find you holding just the lottery ticket, we want to make sure that you've got some place for this money to go. So we want to make sure that it's going to go into your trust and it's going to follow your wishes. So crazy things happen all the time. And what these trusts do is they give you the ability to really control every single thing that's going on. And if you're talking about a revocable trust, it gives you the ability to make changes down the road. So if something comes up and you want to change things, and there's no right, there's no wrong, everybody changes their mind for a whole host of reasons, and you can make those changes. You can change who your trustees are. You can change who the beneficiaries are. You can change in what way, shape, or form people get the resources that you're going to leave to them, that they get the legacy that you're going to leave to them. So if you put all your assets in your trust and you want to make sure that they're there for you and that you can control them and that you can use that money, we tell people if you can use it to go to Vegas, you can use it for yourself. It's in your trust. It's accessible to you. Now, the other question that we get about trusts all the time is is this going to affect the tax impact of my situation? And the answer is, if you're setting up a revocable trust, no, it doesn't impact your tax situation at all. Because the way the trust is set up, your Social Security number is what drives the tax situation on the money that's in your revocable trust. Again, it's all about control. So if you can control it and it's under your Social Security number, any tax forms that are going to get generated that have that money go from you into the name of your trust, your tax ID number is going to be the same. And because your tax ID number is going to be the same, everything that you have in your trust gets reported on your 1040 very much the same as it would get reported if it was just in your name. So creating a trust isn't going to create any more tax headaches for you. It's not going to create any tax implications to make it, and it's not going to create any tax implications to fund it, because everything operates just like it operates when it's just in your name. In addition to that, if you're familiar with how the tax code works, if you pass away owning something, whatever you paid for that asset and whatever it's worth right now, the difference between those two numbers goes away. You get what's called a step up in basis. So here in New England, we always refer to when we talk about houses with people. If you put your house in a revocable trust and you paid $25,000 for your house a bunch of years ago, and something happens to you and your family inherits your house, if when they inherit your house, it's worth $400,000, and they sell your house for $400,000 and they split the money up, they're not paying any taxes on the gain between the 25 and the 400. They get what's called a step up in basis. That basis now becomes whatever it was worth when they inherited it. So if you think about it, if you think about the benefits of a trust and what it brings to the table, it gives you the ability to manage your affairs while you're alive. It gives others the ability to step in and manage your affairs if something were to happen to you, and have the ability to get in and handle things so that they can continue to take care of you. It streamlines the process if something ever happened to you from a probate process. Anything that's in your trust does not go through probate. It goes according to the wishes that you've laid out in your trust that say, if I'm not around, I want my assets split up, A, B, C, or 125, 25, 20, whatever your percentages are, however you want to lay it out, that's how those assets are going to get split up. And from a tax perspective, your family still gets a step up in basis on the assets that you hold in your trust. Now, people will ask us all the time, Jay, what are the downsides of a trust? Why wouldn't I use a trust? And our answer has generally speaking has been, if people feel like they might struggle with the technical concepts of having a trust and what it's doing for them, that may overwhelm people to the point that they might say, we don't necessarily need that. It's kind of overcomplicating things for us, and we're just fine kind of moving on the way that we've already been going. And so then we'll have an additional conversation with clients to talk about other ways that we can hold property that might mimic some of the things that we're trying to do with the trust, but keep down the complexity and try to keep it as straightforward as we possibly can. But at the end of the day, for a taxable portion of a client's portfolio, we really can't come up with the reason that we think it doesn't make good sense for somebody, other than that concern around addressing the complexity of it. Now, we're talking about a revocable trust. We're talking about a trust where you retain complete and total control. We'll dedicate a future show to the complexities around an irrevocable trust. Again, we talked about it earlier. Don't worry about Google lawing these ideas. We'll help explain them and help them make sense for you. But for all intents and purposes, as far as this discussion goes, we want you to think in terms of making sure that you have an updated will and you understand who the executors are going to be, and you understand who the backup agents would be if something ever happened to you. And then we also want you to take away from this conversation the importance of having a trust in place and how it can really help your family and your loved ones manage your affairs while you're with us, pass your affairs on to future generations so that your legacy goes where you want to go, and you're not giving up any flexibility or any benefits as they're written into the tax code as it relates to these assets here. So if you have anything that you want to call the station about or send an email to the station about, let us know and we'll try to answer some of those questions on some future shows. But for purposes of what we talked about today, remember, probate when you pass away, it's an important concept of your plan. And as we mentioned at the end of all of our shows, we feel like estate planning is the ultimate act of love for your family. It's the ultimate ability to let your family know what your wishes are, make things easier on them if they have to be put in that very challenging situation of making decisions for you, and set it up in such a way so that you know your wishes can be carried out, so that your family can spend the right time at the right place doing the right things for you. So we thank you very much for watching the show, and look forward to seeing you at some future editions.